On to part three of the lecture series, employees and consultants. After founders and after intellectual property, one of the areas of most frequent inquiry relates to employees, consultants, what's the difference between the two, how to hire, when to hire, what to do, what types of agreements are important. We'll start with the basic that everyone kind of knows. Most people have been an employee of someone else at some point in time. Employees at a startup ought to have at-will status. You may have heard that before. Quite simply, what that means is that the person can be terminated at any time for any reason or no reason whatsoever, right? So your employment with the company is at the will of the company. That ought to be made clear to employees very at the beginning. We like an offer letter that says, hey, we're going to offer you employment with the company. You have at-will status. Your salary will be X. You'll report to Y. Keep it very simple. Some forms and oral contracts can be misinterpreted, so you want to be careful if you're talking about. One of the things I see as I think is problematic, or at least confusing, is to have this term of employment that says we're going to offer you employment for 3 years, but it's at will. Stay away from these elaborate forms for your employees. You don't need employment contracts for startup companies. An offer letter is fine. It's great. Non-competition agreements. In California, they're not allowed, right? And so the only way you could have that is in connection with the sale of the business, in which case the founders and stockholders will agree that they won't compete, and that's enforceable. But otherwise, it's not enforceable. In California, other states, it changes all the time and depends on a different number of factors, including the position and compensation. So the higher level person, the more intellectual property they've created for the company, the more inside information they have about the company, right? The non-compete, if any, will be more enforceable, right? That's one factor. The length of the non-compete is another factor. Is it 2, 3 years? Or is it 9 months or something like 6 months? I think it's obvious that the lesser the period of non-competition, the more enforceable it is. What are some of the other factors? Are you paying the person? Are you providing them maybe with health insurance during a non-competition period? Hard to say that you shouldn't be subject to a non-competition period, right, where you're sitting on your hands if you're getting paid for that. It's fine, right? And courts will find it generally enforceable. Non-solicitation agreements. 2 flavors. Non-solicitation of employees and non-solicitation of the clients. I think that the more specific they are, if they list clients, list areas of types of clients, list employees, the types of employees that were under you, the bigger the company. As the company grows, you may have different thoughts about what sections to court off. But these are highly enforceable because these are something that the company has as its property, right? These are our clients. This is our list of information. It's our employees. So if you're leaving, we don't want you to touch those. And courts tend to find that highly enforceable because it's a specified reaction to the non-enforceability of non-competition. If I can't say that you can't compete with me at all after having been, we taught you how to do this industry and you have the inside information, I should at least be able to say, you can't steal my clients and you can't steal my employees. So courts will enforce that, and I think it's a great way, depending on the type of company you have, it's a great way to establish a protection for the company early on. We do it with all of our startups, and we find that there's very little pushback on this. This is different, right? But the non-solicitation properly drafted is really effective. Okay, those are employees. Consultants could be subject to some of those restrictions too. But consultants are generally a little bit different, right? Because they're technically working for other people. They have their own company, right? And so they're going to perform services for others. They're not coming to work at your office every day. They don't wear your uniform if you have a uniform. This is a startup, right? They're useful, however, because the company doesn't pay employment taxes on them. They're, essentially independent, right? The company will issue them a 1099, they pay their own taxes. So you don't have them on payroll, you pay them as though they're another vendor. You don't pay taxes or withholding taxes for them, right? But there is a problem. There is a problem. Sometimes there's a confusion between consultants and employees. And we see it happen all the time, right? And it's the following reason. You almost always want to date before you marry. So, Paul, you come to me with a potential idea and you say, Charles, I got this great startup. I'd love you to join on board. You need to provide some services and consulting advice. But you know what? We just met. So maybe not an employment relationship yet. Maybe that's not right yet. But what do you feel about a consulting relationship? Let's date before we get married, right? So let's figure out what happens. And then let's say 6 months down the road, relationship's going great, right? And all of a sudden, I'm wearing the company uniform. I'm showing up every day at 9 o'clock. You're paying my only source of biweekly income, right? I report to you. I come into your office and you're like, Charles, it's time for your review, right? Am I still a consultant or am I an employee? Sounds like I'm an employee, right? The IRS has promulgated a 20-factor test, and I've broken it down to 3 general areas for you because that's otherwise, frankly, boring. But behavioral control, and that doesn't mean like, can you tell me to shut up? But you know what I mean? Like, do you direct where I go? Where do I provide services? Financial independence. Are you providing my only paycheck, right? Am I getting it from others? Are you a portion of my income? And then the relationship of the parties. To whom do I report? Do I report to you? Are there other people inside of that company that can direct my, my actions, right? And where the deliverables go? What's that relationship like? When you put these tests together, you'll find sometimes that someone who starts a consultant often is really an employee after time and morphs, and they haven't made a change in the relationship. And what does the change has to occur is, you got to terminate whatever consulting agreement we have. And the consulting agreement, as we talked about in another section, right? It's probably an agreement that says, I'm going to work for you, you're going to pay me, and I'm going to assign any intellectual property that I create for you, right? It could be different things too. It could be a sales consultant. I'll work for you, I'll sell your software, and you'll pay me X%, things like that. So often you start off with that. And what you need to do is terminate that and go back to the offer letter and bring them on board as an employee, get them, on the payroll, and withhold the taxes. Why is that important? Because you need to comply with all of these and others, and it's a lot. Wage and hour compliance laws, compliance thresholds for federal laws. There's Title VII, the ADA, GINA, ADA, FMLA, right? And then the misclassification penalties. If the IRS has audited you and finds that the 15 or 20 people that you say are consultants are indeed employees, could have problems, right? So companies like, you can imagine a large company like a Geek Squad, right? I'm not sure how they're structured, and I don't mean to actually talk about their structure, but the concept is maybe you go there for services and they're sending someone to your house, right? And then it's going to actually work on some of the technology that you have and fix your DVD player. Is that a person a consultant or an employee, right? I suspect they're all employees, but because they wear the uniform and they show up, and if you go to Best Buy, you could see them in the corner, right? So I feel like those are important. But if their relationship is still structured from a legal perspective as a consultant, then they would have a problem. But startups are particularly susceptible to this because almost every relationship that you have starts as a consulting relationship and then segues over time, right? And that's what we find occurs.
What is the worst situation you've encountered for a startup that had a lot of these legacy 1099 folks, and didn't adjust in time, or what have you seen or heard about?
So, luckily, the worst relationship, the worst problem I've had hasn't involved the IRS, which is good, because if the IRS gets involved, there's a lot of penalties involved. But what did happen is that you had these issues with probably no fewer than 20 consultants that were actually employees. And when did it come up? It came up on an M&A event. And the buyer was looking at this and said, wait a minute, you have a classification problem. And you go through the analysis, and what had to happen is that we had to indemnify against that risk. And it becomes probably a 3-week exercise in doing the research, checking one person, negotiating this, trying to minimize the indemnification provisions. It didn't have to happen that way, but it costs a lot of money to do that. And what happened was that the company was moving so fast that they really just didn't take a break, level set with legal, and say, these guys aren't consultants, they're really employees. Let's really change this relationship and start paying the employment taxes and withholding and paying these guys benefits. They didn't do it, and the deal got done, but it was unnecessarily expensive, and it took longer than it had to. And these are things. And what if it didn't get done, right? Because look, deals that were getting done on September 11th didn't get done on September 12th. So you never know what a 3-week delay on these issues can actually mean for your company, and so you don't want them. It's not a necessary thing. So you want to level set over time. That's the worst thing I saw. Luckily, it didn't involve the IRS.
I have a question are consultants synonymous with contracting work out? And let's say, I feel like there's a potential for consultants to turn into employees, but now let's say you approach a firm, and I'm going to give you X amount of money for X amount of work. I own all IP. Here's a work for hire. Can you explain the differences between the two?
There isn't a difference. That's a consulting relationship. That's the paradigm for a consulting relationship. Employees, or sometimes consultants, can become employees, right? And it's usually that independent consultant that's not working with a firm or an agency where that is more likely to occur. But yeah, the ideal relationship is that I pay you X, you deliver to me Y, and assign all the intellectual property to me.
In a university context, this comes up a lot. 80% of our graduates in the engineering school, for example, are from foreign countries. They're always asking, questions like, can I work at a startup? Can I work part-time at a startup? The startup wants to incentivize me with some equity. I know there are a host of issues. Can I form my own company?
Yeah.
I know there are a host of issues associated with that, but do you have some rules of thumb or some of the issues they should be thinking about if they're from other countries?
Sure. I think that you're going to work hand in hand with the Immigration Council as you start to form a company. Can you own equity? Sure. Right? Can you work for those companies subject to U.S. Immigration laws? Sure. The issue that we see that comes up is, when do you want to graduate that relationship and actually house a visa, like an H-1 visa, inside of the company? There's a process, right? And we usually work with Immigration Council to help onboard someone and get that visa on board, right? There's the other methodologies used is an E-5, which is the investment visa, and people will sort of do that for investment purposes as well.